Hello, welcome. So today we are going to be going over the offer to purchase and contract for North Carolina. So this is one of my favorite ones to go over, and it's lengthy, so here we go. All right, so we are going to put in the information for the seller and the buyer here. So I'm representing Mr. and Mrs. Blue, who are married. So I put in here Andrew Blue and wife Amy Blue. They are purchasing the home from Joe Smith and his wife Ann Smith. Here we're going to put in all the information. So they are purchasing 1234 North Main Street in Concord. And here I have put in the PIN ID, the legal description, and the deed book and page. It's important to put this information in there and make sure it's correct due to the attorney. That's where they're going to gather all their information for getting all the paperwork together for closing. My clients are purchasing this home for $300,000, and we're going to have a discussion, and we're going to go over the due diligence fee and the earnest money fee. So usually what I say here for a good guide is to put about 1% down between your due diligence and your earnest, which for them is going to be about $3,000. So your due diligence fee is going to be your non-refundable fee that is given at an executed contract to the seller directly as a thank you for taking your home off the market and showing them how serious you are about purchasing this home. If you think about it this way, the more money that you're willing to put up, the higher the risk, so you don't want to back out. So, for example, my clients here, they love this home. They're really wanting to purchase it. So, they're going to put up $1,500 for due diligence. Not $15,000, but $1,500. And for their earnest money, they're going to do the same and put up $1,500 here as well. So, that's going to be a total of $3,000. And as you see here for your balance, that's going to be taken off for closing, so be credited back at closing for a total of $297,000. We're also going to check here for initial earnest money deposit that my clients are going to be writing a personal bank or personal check, and they're going to have that to the seller or to the escrow within 5 days. So this check, your earnest money check, is going to be made out to whoever is your escrow agent, and then your due diligence fee is going to be made out directly to those sellers, Joe and Ann Smith. Down here is where we'll go over who the escrow agent is. This can be if your real estate agent's office, if they have an escrow account where they hold money, they can hold it, or you can have your attorney hold it. So for me, we do not hold earnest money or any escrow, so I always say to go to your attorney to have them hold it. For this closing, my clients are going to use one of my preferred attorneys. Now they can use whoever they like, but we are going to use Kevin Link, attorney in Concord. So we're going to type in there, Kevin Link is going to be the escrow agent. The effective date of this contract is going to be when the buyer and seller have initialed and signed everything on the counter offer or the offer to purchase. If there's one thing that has been changed and they have not initialed it, then technically you are not under contract until those final initials get onto the contract. Due diligence. So your due diligence is going to be whenever you do any inspections and make sure everything is good with the home. Like I said, that due diligence fee is a non-refundable that's paid to the seller for a thank you for taking your home off the market. In North Carolina, a typical bank closing is going to be about 45 days. Now, that differs between, what bank you go to, what type of loan, and all of that. So for this one, today's date is January 28th. So we're going to say that due diligence is going to end on February 28th. That's going to give a solid 30 days for us to do all of our inspections. For settlement date, we usually do about 15 days out from the due diligence date. So if we are closing on February 28th, which is this Friday, then we're going to set closing for March 13th. So that's about 45 days, give or take. Closing. So closing is the completion of this whole entire agreement. So this is when we're going to go to the closing attorney. They're going to have the deed ready for you to sign over. You're going to give all of your money if you have any down payment, closing cost, and sign about 4,500 different signatures. No, I'm just playing. It's not that much, but it does feel like that for the buyers. The sellers get off easy. They don't have as much to sign. So I want to go over special assessments, proposed assessments, and confirmed special assessments. I feel like I get a lot of questions like, I've never heard of that. What is that? So a special assessment is a charge against the property by a governmental authority in addition to ad valorem taxes and recurring governmental service fees levied with such taxes, or by an owners association addition to any regular assessment dues, either of which may be a lien against the property. A special assessment may be either proposed or confirmed. So what I like to say is, if there's a sidewalk being put in by the HOA and they are charging all the homeowners an additional amount, then that is going to be a special assessment. The seller has been notified of that, and they have to let us know, if that is happening. Fixtures and exclusions. This is a big paragraph I like to go over, have my clients read over, when they have time. So what I like to say for this is, a good rule of thumb is, if you have to take any type of tool to get something off of the wall, then it is considered a fixture. For example, if you have a TV mounted on the wall, the TV is not directly mounted to the wall, but is in a mount, which the mount is directly mounted to the wall. So the mount is considered a fixture, but the TV is not. So if you want their 80-inch TV that's in the living room, then we would have to put that in as personal property to be conveyed with the property. Items leased or not owned. So the big one here is going to be fuel tank. I see this a lot, especially in homes out near us, that there's fuel tanks on the property. So you want to make sure that you know if there's any fuel tanks, and if you own that fuel tank, or if you lease that fuel tank. If you lease it, then you don't own it. It is owned by the company you lease it from. The contents inside of the fuel tank you have purchased and you owned. So it's important to know that. So there is a fuel tank on this property, so that is not going to convey. So we're going to put in fuel tank there. Other items that do not convey. So if, for example, if there was a chandelier that the seller did not want to convey with the property, it's her great grandmother's, then we would write that in there. But as of now, there is none. Personal property. The following personal property will be transferred at no value. So there was a Samsung 3-door French door refrigerator in the property. It had a really cool one of those touchscreen things. So we put in here the Samsung. We put the item number and the description, so that we are very specific on what is to be conveyed at closing, so that the seller couldn't go in there and exchange that refrigerator out for a more basic fridge that the buyer did not want. Buyer's due diligence process. So your due diligence process is going to be when you conduct any and all inspections, surveys, anything to do with purchasing the home. You're going to find out all your information here. So you're going to go over your loan process, make sure you're getting all the documents to your lender. Property investigation is going to include inspections of the property, review of documents, insurance, appraisal, survey, zoning and governmental regulations, flood hazard, utilities and access, streets and roads, and fuel tanks. So you're going to make sure there's no fuel tanks on the property. If there is, locate them. You want to make sure that the street or road is private or public. If it's private, then if you get snowed in, then the county is not going to come out and clear your roads for you, because it is a private road. Along with that, you want to make sure that there's a private road agreement. If not, how is the road being maintained now? Is it just a bunch of people who have agreed to get along and maintain the road, or is there issues? You want to make sure you know that information before purchasing it. If you have to sell or lease any existing property, this is where you make sure that you are getting your home under contract in order to get the new loan. Make sure everything's good with it. Repair, improvement, and negotiations. I like to highlight that the property is being sold in its current condition. Just because you do an inspection and you find issues with the property does not mean that the seller has to fix those issues in order for you to purchase. If you back out of the contract and the seller knows about issues, then they have to disclose that to a new purchaser. The real estate agent does, any material facts. But just because you found something on the property does not mean it has to be fixed. But if you do want it fixed, you're going to negotiate that during your due diligence period. Buyer's obligation to repair damage. So if something happens in the home and something went wrong, the hole got accidentally elbow went through sheetrock, you're going to have to fix that as a buyer because it still is the seller's property. Buyer's right to terminate. So if you decide 2 days before due diligence that this just isn't the home for you, you need to back out, then you can. You can back out for any reason or no reason at all. In order to get your earnest money back, you have to terminate before 5 p.m. on that due diligence date. So for this contract, we put on there February 28th is our due diligence date. So we would mark in our calendars at 5 p.m. That is the last day to back out in order to get your earnest money back. Buyer's representation. So the buyer does have to get a loan, and it's going to be conventional, and they are going to be doing a fixed rate loan, and the principal amount of $280,000. They'll be putting down $20,000 for a term of 30 years, not to exceed 3.9%. The buyer does not have to sell any other property in order to get a new loan, but if they did, we would identify how we were selling that home here. Residential property disclosure. The buyers have received that prior to signing this agreement, and they have received the mineral oil and gas rights. I will go over these in more depth in another video. Buyer's obligation. So they are responsible for any proposed special assessments on the property. So buyer shall take title subject to all proposed special assessments. So if there's anything proposed on the property, say the HOA has decided that they would be putting in the sidewalk, but it won't be until next year. The seller has let you know of that as a buyer, then you are going to take over possession of property knowing that that special assessment is proposed. Responsibility for certain costs are going to include any costs that are charged by homeowners association. So if they charge to transfer the ownership in the HOA, the buyer is responsible to pay that. Any membership fees or any of those, determining restrictive covenants compliance, appraisal, title search, title insurance, any fees charged by the closing attorney for document prep, recording the deed, and any preparations of any instruments used in the purchase. Authorization to disclose information. You as a buyer have to give your lender the authorization that they can speak to the attorney, the buyer's agent, anybody that is representing you in the purchase of this home. Seller representation. So we're going to check here that they have owned the property for at least 1 year. And then down here, we don't have to check that it's a lead-based paint just because this home was built in the early 2000s and therefore was not built prior to 1978, so it does not have lead-based paint. Assessments. The best of the seller's knowledge, there are no proposed special assessments and there are no confirmed special assessments on the property. Homeowners and association and dues. So there is no HOA on this property, but if there was, we would type in here, for example, Oldenburg HOA would be the name of it. The dues are $150 per year, so not much. And then we would type in the Oldenburg HOA information here. So that's just if there is an HOA, give an example of what that's going to look like for the buyer and the seller. Seller's obligations. So if the seller, they have to give evidence of title payoff and make sure that all liens are satisfied at time of closing. They have to give the attorney and everybody the authorization to disclose this information for any title insurance policy or anything along those lines. Access to the property. So seller has to give reasonable access to the property so that the buyer can conduct their due diligence. If the property is vacant, then it's really not a big concern if the inspections are on different days. But if the inspection if the home is occupied, we want to try and get all inspections on the same day. Sometimes that doesn't work, but it just helps the seller out and not having to get, if they have a lot of kids or an elderly parent, get them out of the house. It just makes it a little bit more convenient for them. Seller has to remove any property that is not stated to stay in the contract. And they have to just make sure that all the liens are paid, and they give good title and legal access at time of closing. Deed, taxes, and fees. So here I put as directed by closing attorney. So for example, say that Mr. Blue is the only one on the loan. Mrs. Blue is not on the loan. So Mrs. Blue would like to be on the deed, and they're going to let the attorney know that she would love to be on the deed, or she would like to be on the deed, and the deed is to be made out to both of them, even though the loan is just in his name. It really does not matter as far as ownership goes, because if they are married in North Carolina, the wife has just as much right to the home, even though she's not on the loan, as the husband does. But that's where we put that. So the buyers are asking that the seller pay $2,000 towards their closing costs. So we'll put that in there. Seller's failure to comply and breach. So it's important to know that the seller is legally bound by this contract, that they cannot back out. If they do back out, then the buyer has a right to take them to court in order to make them sell their home, or they have to refund the buyer and reimburse them for all of their fees. Prorations and adjustments. It's important to know that if we will be closing on March 13th, then the seller is responsible for taxes from January 1 until day of closing, so March 13th, and then the buyer is responsible for March 14th, the day after closing, until the end of the year. They're going to collect both of these taxes, put them into escrow, and they are going to pay those taxes when the bill comes out. They will also do this for any rents or any homeowners association dues, and all of that. So the buyers will be getting a home warranty not to exceed $600. What I like to say about a home warranty, they do have limitations and conditions for their coverage. So I like to say it's like any warranty on your car. You call, they're going to look at it, and if it's under that warranty, they'll fix it. If not, then they can't help you out. One major thing to keep into consideration is a roof is not under your home warranty, so that is not covered. Delay in settlement and closing. So you have 14 days past the settlement date that you are not in breach of contract until after that 14th day. So for example, if you had a sickness in the family and you couldn't leave work for the day of closing and had to reschedule for the next week, then you have that 14-day grace period. Don't have to worry about any addendums. Here this will be where the buyer and seller sign. Wire fraud warning. It is important to read your wire fraud warnings. Make sure you are not wiring any of your fees anywhere that you're not supposed to. Here's the information for the buyer's firm and the seller's firm. And then down here is acknowledgement of all receipts of money.